Well, 2 more days. Yeah, and that Saturday and the week off. We're off. It's off. We're not coming in. But we have MBAs, so we kind of busy.
Or there's still a
Yeah, we're maximum. I know. Already.
Oh, now you can't eat.
Yeah.
Well, that's part of my diet. I'm going back on my diet.
The read
How was your son's wedding?
Huh? Oh, it
How
was
was
great.
your
That was great.
oh.
It was awesome. 4 days of partying and eating and drinking. And I only gained 3.5 pounds. That's not bad.
That's impressive.
Better than when you lost 16.
3.5. That's not bad. All right, everybody here. Did you guys get through this reading assignment? Okay, and you get a break for next week. Then you guys are going to eat. So, going forward, I'll remind you of this again, but going forward, this is all rule-based until we get to issue preclusion and stuff like that. So if you look in the textbook before a case or a series of cases, at some point, the authors will highlight the rule that the cases are going to be discussing, okay? So you need to pull out your supplement when you see the rule and go to the rule and read it. Otherwise, the case isn't going to make any sense because these rules, these cases don't provide the rule. The cases don't stand for the rule. The cases are interpreting the rule. They're telling you what certain words or portions of a rule mean, or they're providing a test for how they're going to apply that rule. Okay? So you need, in mining for the gold, to find what the interpretation of a portion of the rule is in the case. And that's what the case you think stands for. And then we'll see how you get it. Okay? Lastly, at the end of each chapter, there are multiple choice questions. It's kind of self-test. Okay? So when we finish a chapter, you should do those questions, because those are going to be multiple choice practice and specific to our book and to what we've been studying, rather than Kaplan or some other source that I might go to. Okay? The first source is going to be what's in the back of each chapter. So you got a week off next week, right?
Yes.
So during that period, before you start reading the next chapter, go over those cases. I'm not gonna give you, those questions. I'm not gonna give any questions tonight. You go home, take a little break, okay, but then go over those questions. Then you go to the next one. So we're gonna start now with the portion of the chapter entitled Ethical Limitations
Thank you.
on Pleading and Sanctions. And that's something you guys ought to pay attention to, because what that means is if you screw up, you're going to get sanctioned. And you may not like that, because in federal court, the courts have the power to sanction you, the lawyers, and not your clients. So where's the money coming from? It's coming out of your pocket, okay? Let's go to Rule 11, A and B. And that's on page 290. Let's see. Clara, would you read us Rule 11A and B? We're not C, just A and B. Okay.
So Rule 11A, signature. Every pleading, written motion, and other paper must be signed by at least one attorney of record in the attorney's name, or by a party personally if the party is unrepresented. The paper must state the signer's address, email address, and telephone number. Unless a rule of statute specifically states otherwise, a pleading need not be verified or accompanied by affidavit. The court must strike an unsigned paper unless the omission is promptly corrected after being called to the attorney's or party's attention.
B.
B, representation to the court. By presenting to the court pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, an attorney or unrepresented party certifies that to the best of the person's knowledge, information, and belief formed after an inquiry, reasonable under the circumstances. 1, it is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needless increase the cost of litigation. 2, the claims, defenses, and other legal contentions therein are warranted by existing law or by a non-frivolous argument for the extending, modifying, or reversing existing law, or for establishing new law. 3, the factual contentions have evidentiary support, or if specifically so identified, will likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. And 4, the denials of factual contentions are warranted on the evidence, or is specifically so identified, are reasonably based on belief or lack of information.
Okay, so looking at 11A, notice it says every paper filed with the court must be signed by the attorney or a pro per. But for your purposes, it's going to mean an attorney, right? So everything that is every paper that is filed with the court has to be signed either by you or an attorney in your firm. And it's not just that you're signing it. By signing it, you are representing to the court that you've done your due diligence before filing whatever, especially if it's a complaint or an answer, that you've done your due diligence. You haven't just had a client come into your office, sit down and tell you, this is my story. And then you say, okay, I spotted all the issues from all of the facts that you gave me. And then you file a complaint based upon, let's say, all the torts that you can think of from what they told you. You're supposed to do an evidentiary investigation. What does that mean by evidentiary investigation?
Talk to the other party. Talk to.
Well, you probably aren't going to be able to talk to the other party
The other
because
party.
assuming they have a lawyer, they will
Yeah, the
lawyer
party's
up.
attorney.
Interview witnesses.
Mhm.
Okay, you ask your client for a list of witnesses. If it's an auto accident, you may want to go out and take a look at the intersection. Okay, see if there are any issues related to the intersection. If the police were called and there was a police report, you may want to get a copy of the police report before you file anything. Because your client's sitting here telling you that the other party's at fault, and you get a copy of the police report, and guess what? Police report says your client's at fault. Now, that doesn't mean you may not file it, because at that point you may send it over to an expert who you use from time to time. And he may say, no, I think it's in California, it doesn't have to be 100% liability. It can be, 60-40, 80-20. But you got to do your investigation. If it's a commercial matter or a real estate matter, you may want to, get some records, get documents, do what you can before you actually file something. That's what you're representing to the court, that you've done that. That you've checked out the law. You've done your research. You don't just file something and then, as the attorney did in that one case, file a lawsuit without having read the statute that says that you've got to file a claim with the government first. You've got to exhaust your remedies. Okay, so you got to do your research. So you're representing the court that you've done that. And if it comes back, if you didn't do that, and it comes back and it bites you in the butt, you're going to get sanctioned. And not only is that going to come out of your pocket, but how do you think your first impression is going to be with the judge? This is not something you want to do. Okay, so you need to do your homework before you file your complaint. Now, every paper filed with the court must be signed. Okay, you think that includes discovery, like deposition notices, interrogatories, interrogatory responses, requests to produce documents, responses to requests to produce documents. Yes? Yes? No. No. Look at Rule 11D. Everybody looking at 11D? It says that discovery isn't included. Why? Because discovery requests and notices and responses are not filed with the court. That's between the lawyers or the parties, okay? Because why? The court doesn't want to be burdened with all this paper. Or even though we now are doing most of this by internet and it's data-based, they still don't want to be inundated with all this data, okay? It's just too much. That's between you and the opposing counsel. And if there are motions related to it, like we'll look at it later, motions for summary judgment, which are based in part on discovery responses, then you just list those responses and attach copies of just those responses for the court. You don't give the court everything, okay? So discoveries, not part of Rule 11. And pay attention to that, because guess what winds up being a multiple choice? Okay? And they'll be, you know, and that's one of the trick questions. So you have to know for sure that discovery is not something that's subject to Rule 11 sanctions and requirements. Certification. First of all, that's 11B. You're not, going back to 11A, you're not required to file a verified complaint or answer. What does verified mean? Verified means that you're signing it under penalty of perjury, that everything in there is true. Notice the language of B is by you're presenting to the court a certification to the best of the person's knowledge, information, and belief, formed after inquiry reasonable under the circumstances. So it's information and belief, not penalty of perjury. If you ever get, when you're in practice, if you're on the defense side and you get a verified complaint that's signed under penalty of perjury by the attorney and or the party, that everything in there is true and correct, it also requires you to file a verified response. So at that point, red lights are going off all over the place. You have to not only do your reasonable investigation, but you got to make sure that everything that you put in your answer is true and correct. Now, how often do you see a verified complaint? Almost never. Many times, the people who do file verified complaints do it because they don't know what they're doing. Are they? But you never want to file a verified complaint, because now you as the attorney are stating with your bank account on the hook that everything in this complaint is true and correct. All right? Under penalty of perjury, which theoretically you could be prosecuted if it turns out not to be true. Now, how often would that happen? Who knows? By the same token, you've now certified under penalty of perjury that something's true. What if it turns out that it's not true and somebody reports you to the state bar? So you don't want to do that. You may in good faith believe that it's true, but very often, especially at the inception of a case, you may think you've done all the research that you're supposed to do and checked everything out, but there are a lot of stuff that you still don't know. And the first thing you gotta remember is never believe your client. Never believe your client. That doesn't mean you have to disbelieve them. Just don't believe them. Okay? Yeah.
What if it's not something you put in there by mistake, but something that you believe to be true at the time, but then later through discovery is proved not to be true by the other side, whether it be through discovery or in trial later on, could then you go after opposing counsel later?
Well, if it's not a verified response and it's just a Rule 11 certification, you're certifying that to the best of your knowledge, information, and belief formed after a reasonable inquiry.
I'm saying if it is verified, if it's a verified complaint and you're doing a verified response, and then later in discovery, the person who filed the complaint ends up being proven wrong about a fact, whether it be through discovery or whether later in trial or something like that, could you then report that attorney, theoretically speaking, to the state bar for filing a verified complaint?
You could.
Okay.
Now, the reality is there's so many complaints with the state bar, okay? Yeah, they eventually they'll get around to investigating it, okay? And they'll ask you why did you do this, and what steps did you take before you verified the response, and the complaint, yada yada yada. Okay, more likely than not, nothing's going to happen, but you don't want to even be reported. Okay, you don't want to go down that road. And there are also there are ramifications of verifying something as being true, and then it's proven not to be true during the course of litigation, that they can get an instruction from the court that you lied, or that your client lied, okay, in the complaint. Whereas if it's just a Rule 11 certification, it's nothing. It's not evidence. But if it's a verified complaint, it's like filing an affidavit. Or testifying under penalty of perjury. You don't want to do that. And you don't want to do that to your client just to try and screw over the other side. It's dangerous, okay? And there's no need for it. So everybody understand the difference between certification and verification? Okay. Rule 11B, notice the words by presenting to the court, yada, 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 whether by signing, filing, submitting, or later advocating it. What do you think that means? By later advocating it.
Like if they present it later on during the trial?
Doesn't have to be in trial. You could be at a hearing. You could be at a hearing on a motion where you're arguing something, and you argue something that you hadn't necessarily put in your complaint or your answer, but you advocate something. You can be sanctioned for that. Okay? And what it's getting at is by presenting to the court a pleading, written motion, or other paper whether by signing it or say you don't sign it. Somebody else in your office signs it. Okay? And you go into court and you advocate what's on that paper, then you can be sanctioned, even though it was somebody else who did it. Get it? Or your client filed it when he was improper and he signed it, and you come in and you advocate what he signed or what's in the complaint, then you're on the hook too. That's what advocating means. So if somebody hands you a file the night before a hearing and they tell you to go in and argue this motion, okay? I can't tell you the number of times I have heard while sitting in court, some young lawyer come in there, and when the judge starts grilling them about something, they say, oh, I just picked up a file last night. Okay. And then the judge says, well, did you read it? Well, I just picked up the file last night. It's not my file. Okay, but you're advocating what's in that motion, aren't you, counsel? That's right. Well, did you know that it's not true, counsel? So you need to read it and read the other side's paper. And there may be something in the other side paper that causes you to go, oops. We didn't know that when we filed our complaint or whatever it is. You may even want to call the lawyers who's responsible for the case and say, you know what? Have you even read what the other side's saying? Do you know that this is true or not? Well, why don't you contact our client? Contact the client. Oops. All right, now you've done what you're supposed to do, so you're going to make sure when you go to court, you don't advocate what's in the complaint. In fact, if called upon by the court, you may want to say, Your Honor, we're going in a different direction. Okay? So you got to be very careful what you say when you go to court, just like what you file. All right? B2. The representation in B2 is you're representing that you've checked out the law and everything in your complaint is properly researched, and these are all the proper claims or defenses. Notice, however, also included in there is a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. Okay? You get more into this in con law, because in this class, we're not talking about the substantive law, but you may be, for example, Brown versus Board of Education. You guys know about Brown versus Board of Education? So Plessy versus Ferguson was the law, separate but equal. And they're filing a lawsuit against all these school boards saying that they violated the 14th Amendment to the Constitution, even though Plessy versus Ferguson was the law. But they were making a non-frivolous argument to change the law, to create new law. You can do that. And you can say that in your complaint. You could say Plessy, you can either say it violates the 14th Amendment and leave it at that, or you can say Plessy versus Ferguson has been the law for 100 years, but it's wrong. Okay? That's fine. You can do that. but it has to be non-frivolous. You know what frivolous means? Anybody? This is a term of art, you gotta know. What does frivolous mean? Who can look it up real quick? Frivolous.
Is it like value?
No.
It's not having any.
It means frivolous means it's not meritorious. Okay? So non-frivolous means that it's meritorious. But you're gonna see frivolous used a lot. And it's basically based on an old English word that's derived from frivolity. You know what frivolity means? Silly. Fun but not serious. Okay? That's frivolous. It can't be a frivolous argument. It has to be a legit, serious argument. Okay? I guess another word would frivolous also is not serious. Okay? B, 3, and 4. We're talking about factual contentions that have evidentiary support, and the denials have factual contentions that are warranted on the evidence. That means you've done your factual investigation. Okay? By evidentiary support, what does that mean? You've either interviewed witnesses, or you've interviewed witnesses, and you have an investigator who's interviewed witnesses, or you got a police report. I mean, once you get the police report, that's probably enough. Okay, for initially to file a complaint. You don't have to go out and interview anybody else unless you see the names of some witnesses in the police report and it's not clear from the police report exactly whether or not what your client is saying is true. So you call up a couple of the witnesses, or better yet, you have your investigator do it. Okay, just to find out if this is accurate. It's not that tough. There's really no mystery behind this. But does everybody understand now what you're representing to the court and what you're required to represent? Okay, can't just file a complaint. Well, you can.
But it gets sanctioned.
But it's at your own risk. All right. Let's go to, in the textbook, page 417. We're going to go through some of these problems, okay? So we'll start this time with Clara.
So notes and problems?
Yeah.
Is that okay?
You don't have to say start with Rule 11, just go to A.
A party calls opponent on the telephone, threatening her with a lawsuit that party knows to be groundless. May party be sanctioned under Rule 11?
What do you think?
No, because they're not filing anything. It's just over the phone.
That's right. Okay, B.
So B, is there a different result if lawyer rather than party makes the telephone call? No, still the same thing because it's not filed with the court.
But if a lawyer calls somebody up and threatens them with filing a complaint, or sends a letter threatening to file a complaint, you can be prosecuted under state law for extortion. And or Now, how often would that actually happen? Who knows? But that's also subject to a state bar investigation, and state bar can slap you on the wrist for doing something like that. So you never want to, if you're the lawyer, you never want to threaten somebody with a lawsuit. Okay? You just file it. You can call them up, or you can call their attorney up and say, I've been retained by your client and they have this, they have a claim or claims against your client, opposing counsel's client. You think we can resolve this? I mean, you don't have to say, or I'm going to sue you. Just, okay? But there's a famous see you in court. Okay? C.
C, lawyer files a groundless interrogatory. May lawyer be sanctioned under Rule 11?
No,
No, because he filed.
that's discovery.
Oh,
Look at number 11D. What does it say? Doesn't apply to discovery.
oh, that's right, we did go.
Yeah, we just went over that.
I know.
Okay?
Okay.
All right. Right.
Client rushes into lawyer's office, telling him the story of defendant's actions that suggest several forms of liability. Lawyer drafts and serves a complaint pleading the claims described by client. Defendant answers, denying all the significant allegations of the complaint, and in the disclosure required by Rule 26A1A, attaches documents, photographs, and affidavits from disinterested persons indicating that most of the client's story was entirely false. Is there a violation of Rule 11, and by whom? By whom would be the client's lawyer under
Why don't you look up
the
26G.
Rule 26.
Yeah. What does that say?
Thanks, 26. So is it on 352?
26G?
Yeah.
No. Wait a minute.
Yeah, it is.
Where is it?
Signing disclosures, 352. Signing disclosures and discovery requests.
Oh, I'm sorry. I was looking at something else.
That's 11B3.
Yeah. Go ahead.
126G?
Yeah.
Okay. Every disclosure under Rule 26A1 or A3 and every discovery request, response, or objection must be signed by at least one attorney of record in the attorney's own name, or by the party personally if unrepresented, and must state the signer's address, email address, and telephone number. By signing, an attorney or party certifies that to the best of the person's knowledge, information, and belief formed after reasonable inquiry. A, with respect to a disclosure, it is complete and correct as of the time it is made, and with respect to a discovery request, response, or objection, it is consistent with these rules and warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. Not interposed for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation, and neither unreasonable nor unduly burdensome or expensive, considering the needs of the case, prior discovery in the case, amount in controversy, and importance of the issues at stake in the action. And And go to failure to sign.
No, this isn't, well, failure to sign, yeah, go ahead, read it.
Other parties have no duty to act on an unsigned disclosure, request, response, or objection until it is signed, and the court must strike it unless the signature is promptly supplied after the mission is called to the attorney's or party's attention.
Look at 3.
Sanction for improper certification. If a certification violates this rule without substantial justification, the court, on motion or on its own, must impose an appropriate sanction on the signer, the property on whose behalf the signer was acting, or both. The sanction may include an order to pay the reasonable expenses, including attorney's fees caused by the violation.
Okay, notice the term must impose, so it's not discretionary. All right? So let's go back and look at the question again.
So the question getting asked.
Is there a violation of Rule 11?
By whom? I said it was by the client's lawyer, because he filed a complaint without,
Well, it's really a violation of Rule 26, isn't it?
26.
26G. It's a violation of both Rule 11 and 26G, because what 26G says, if it violates any of the other rules, which would be Rule 11.
Right. And then
Right.
sanction.
Okay, so they can be sanctioned under, it's really Rule 26G and Rule 11. Okay?
B, it says, it asks, if under these conditions, lawyer has violated Rule 11, how will his stance toward future clients change? I guess he's gonna.
Yeah, by
investigate-
both of them.
He's gonna investigate both, everything. Does the rule in effect require that lawyers be skeptical of their client's stories? Yeah, because he didn't do his proper, research. His client's claims were baseless.
Yeah, Yezel has a slightly different approach. He says, no, a lawyer should just check out all client stories. Not being skeptical, you just check it out. I think it has, I think it's a distinction without a difference. Be skeptical. Okay.
I have a question. So is the main
Yeah.
reason that it violates Rule 11 because he didn't do his due diligence and doing his research, but also it would be because he didn't sign it too. There's no facts that says he signed it
Yeah.
and or filed it to the court. So
Well, that would be under 26.
okay.
Specifically, under 26, didn't sign it.
Right.
Okay? So, yeah, if you don't comply with the rules when you file with your opposing counsel discovery, you can be sanctioned, but it's through Rule 26 rather than Rule 11. Okay? You got to keep that distinction in mind. Rule 11 doesn't apply to discovery. It's through Rule 26. But it's basically the same kind of certification. You're certifying that to the best, that it doesn't say it's true. It says it's full and the answer is full and complete. Okay. All right, next.
That was Trish.
Oh, you want me to go? No,
I can do it.
no, I'm gonna go this way. Isabel, come on, let's go.
Okay, suppose in the case described in problem 2, the defendant wanted to seek sanctions under Rule 11. Could defendant file a motion for a summary judgment to get the claim dismissed and include a request with it for the attorney's fees expended defending the meritless claim?
Look at Rule 11C2.
Well, it says they must be made separately
That's right,
from the other motions.
right.
So,
It's a separate
Okay.
motion for attorney's fees for failure to comply with rule 11. Okay? Look at B.
could defendant file two separate motions for summary judgment and for Rule 11 sanctions on the same day and seek an immediate hearing on both?
Look at 11C2.
I'm guessing they
Why
can't.
don't you read that out loud?
11C2. Okay. A motion for sanctions must be made separately from any other motion and must describe the specific conduct that allegedly violates Rule 11B. The motion must be served under Rule 5, but it must not be filed or be presented to the court if the challenge paper, claim, defense, contention, or denial is withdrawn or appropriately corrected within 21 days after service or within another time the court sets. If warranted, the court may award to the prevailing party the reasonable expenses, including attorney's fees incurred for the motion. So
Go
it
back.
would be,
What's the question?
if they were to file two separate motions, one for summary judgment and then the other one for sanctions on the same day, and seek an immediate hearing on both, well, the court would have to set the time, but
No,
it
no.
could,
But this is called the safe harbor provision. You have to send a copy you prepare the motion and you send a copy of the motion to opposing counsel. And the way you're supposed to do it is you send them a letter with a copy of the motion, and in the letter you specifically point out those portions of their pleading which are incorrect and need to be fixed. And they're given how many days?
21.
All right, they're given 21 days to fix it. So that's called the safe harbor provision. Do you understand what safe harbor means? What?
Gives them a time to rectify it.
Yeah, but safe harbor goes back to naval warfare.
Like neutral area.
Yeah, that's you can't fire at them when they're in the safe harbor. Okay, so they got 21 days before you can fire it, before you can file it with the court. And if you file it with the court before the 21 days are up, they can get sanctions. Okay? And the whole idea is you give them 21 days to fix it. And if they fix it, then there's no motion. And then the court doesn't have to get involved. And that's what this is all designed to do, is to save court time and to avoid unnecessary motions. Okay? All right. You got to remember the safe harbor provision. There's another one that shows up on multiple choice. Okay? Where a lawyer will just file a motion without sending it to the other party. And that's the way the question will read. And as you're sitting there, you're going through this stuff really fast. If you're not thinking about safe harbor, you may answer the question wrong. Okay? Daniel, number 4.
In Howell versus Garrison, Supra, page 377, the district court opinion accurately stated that a decision of the 11th Circuit suggested that an at-will employee could not state a claim under the federal statute in question. A, suppose that Howell's lawyer did not know about the decision because he had not adequately researched the case. What provision of Rule 11 provides a basis for a sanction? That would be a 11B2.
Yep.
The claims, defenses, and other legal contentions therein are warranted by existing law or by a non-frivolous argument for the extending, modifying, or reversing existing law or for establishing new law.
All right. B.
In the actual Howell case, the plaintiff's lawyer knew all about the 11th Circuit precedent. Suppose in the wake of the district court opinion dismissing the case, the defendant had sought Rule 11 sanctions against the plaintiff's lawyer. What phrase in Rule 11 will provide Hattle's lawyer with grounds to resist the sanctions?
We just went over that.
I guess if he was modifying or reversing the existing law?
Yeah, non-frivolous argument to reverse existing law.
Okay.
Okay?
Yeah.
Okay, number 6. Trish,
Number 6 or number 5?
number 6.
Okay. Knowing the structure of the rule is important, but this does not give the student a sense of the kind of conduct for which lawyers and clients find themselves in trouble.
Seven.
Consider some.
No, you're on 7. 6.
Oh, you know what? I have a different book than you guys, so maybe I just. So mine says 5.
Yes.
Start with.
Lawyer files
Lawyer- Yeah. Okay, that's my 6. I mean, that's my 5. Okay. Lawyer files an answer alleging the statute of limitations as an affirmative defense. At the time the lawyer files the answer, she reasonably believed that the facts warranted such a response. Lawyer later learns that a salient event occurred later than she previously thought, and the statute of limitations therefore has not run. A, does the lawyer violate the rule by failing to file an amended answer? Compare Rule 26E, which requires supplementation of responses to discovery requests. I would say no.
Go. What does Rule 26E say?
26E.
You don't just say no. You got to go to the rule.
All right. Oh, here it is. Okay. Okay. Supplementing disclosures and responses. Let me see. 26E. The whole. Okay. In general, a party who has made a disclosure under Rule 26A or who has responded to an interrogatory request for production or request for admission must supplement or correct its disclosure or response. A, in a timely manner, if the party learns that in some material respects the disclosure or response is incomplete or incorrect, and if the additional or corrective information has not yet otherwise been made known to the other parties during the discovery process or in writing, or as ordered by the court.
So what's the answer?
No, I think
Because?
no, because she reasonably believed the statute of limitations had run, and she
Well, what does 26 require? 26 is the one that requires supplementation of something.
right, of disclosures and responses. So they said that she did it in a timely manner.
Well, of what?
Discovery
Yeah.
request.
Yeah. Is rule 11 complaint or answer? Discovery?
Oh, right. That's right. Discovery has, no.
Rule 11 doesn't require a supplementation of an answer. Okay? So the answer is no. Because Rule 11 does not require a supplemental answer.
Okay.
Okay? Supplementing answers, supplementary or supplementing responses for discovery. Okay? Second, B.
Does lawyer violate the rule by orally asserting this defense at a subsequent pretrial conference? I want to say no. Hold on. because
That's subsequent advocating.
right, okay, I was just looking for the rule. Subsequent advocating.
11B, you subsequently advocate something that isn't true. Remember I just went through that?
Yes,
So, yeah, you can get sanctioned for that. That's
so,
the
yes.
counsel. Did you read your file? Okay. And since we're talking about that, Clara, why don't we do Walker versus Northwest? Page 419.
So. Long, but I put, so this is a dispute over a mine trust fund. And James Macy is the attorney that filed the complaint in the district court on behalf of the Walkers, alleging breach of fiduciary duty against Northwest Corp and other officers and employees. The complaint stated that jurisdiction was based on diversity, since the applicant and some of the defendants are citizens of the state. He put that Walkers are both from South Dakota. Northwest was a Minnesota corp. The complaint did not allege the other plaintiff citizenship precisely, but stated many of them were South Dakota residents. So Northwest Corp attorneys wrote that Macy informing that they wrote Macy informing that his complaint showed on its face that there were no diversity jurisdiction because longstanding authority requires complete diversity. So
Why was there no diversity?
because I think he did not state specifically, because he filed against the other numerous officers.
No, you just said why earlier. They stated that there were that numerous defendants were South Dakota residents.
Yes.
If the plaintiffs are South Dakota residents and the numerous defendants are South Dakota residents, then on the face of the complaint, there's no diversity, because that defeats diversity.
Okay.
Get it?
Okay.
That's an attorney who should go back to law school. Okay?
No. Okay. So
Or never should have gotten out of law.
never should have gotten out.
Okay. All right.
The
So-
letter also stated that if Macy did not dismiss a complaint, then Norris will seek sanctions, including attorney fees. So Macy acknowledged, Norris, that he did receive the complaint, but he didn't move to dismiss the complaint. He did receive the letter. He acknowledged that he received the letter, but did not make any explanation, any response or anything.
He didn't do anything.
He didn't do anything, right?
Okay. So then what did the defense attorney do?
So they moved to dismiss and they also award for sanctions. So
And what did the district court do?
the district court granted motion to dismiss for lack of jurisdiction and sanction attorney Macy. So the Walkers and Macy appealed. So they contended that Rule 11 does not require in-depth inquiry to determine that defendant citizenship before filing a complaint or diversity on citizenship.
Well, before they appealed, what did the district court do with respect to sanctions, since that's what this section's all about?
Motion to dismiss and sanction Attorney Macy under federal rule. So awarding $4,800 in fees and expenses.
For how much?
$4,800.
Yeah. Under rule, we just studied it. Yeah, rule 11.
Mm-hmm.
Okay, so what's the issue?
I have two issues. I put down, did the district court abuse its discretion of its basis in ruling on the erroneous view of the law? And I also put down that the Walkers and Macy's next contended that the district court abused its discretion in awarding monetary sanctions instead of dismissing the complaint.
Well, what's the rule in this case? What the courts say about Rule 11 sanctions? This is about sanctions.
Mm-hmm.
This whole case is about Rule 11 sanctions. To say that the issue in this case is, are Rule 11 sanctions appropriate under these circumstances? Where somebody gets a safe harbor letter,
For the 21-day, yeah.
right?
Okay.
And they took safe harbor, but then they didn't do anything.
Mhm.
And what happens if they don't do anything after the 21 days? Is it appropriate to sanction them under Rule 11? What's the answer?
Yeah. They did. They said, well, they affirmed with the district court on the rule, on Rule 11.
Well, what do you
sanctions.
have for the rule of the case?
I didn't find the rule in here, but I found the rule in the code.
Okay. So do you have down that it's appropriate to sanction them?
Yes.
What do you have?
Mm-hmm.
What do you have?
I put down that the appeals court saw no abuse and discretion in awarding monetary sanctions.
Okay. Okay, good. I have for the rule of this case, Rule 11 sanctions are appropriate when an attorney's filing is clearly defective and he takes no steps to amend or dismiss. Okay? And applying that rule to the facts, sanctions were appropriate because plaintiff failed to allege that all the defendants were domiciled in a state other than South Dakota, did not allege citizenship for many of the defendants, and failed on appeal to identify which defendants should be dismissed to provide diversity. Plaintiff contended that the trial court should have inquired about all of defendants' citizenships before awarding sanctions. And on page 421, the court wrote, "The court is not obliged to do the attorney's work for it." Okay? So you get the idea about how courts look at these things? Let's look at notes 1 through 3 on page 421. Question 1, what portion of Rule 11 did the plaintiffs violate? Anybody?
Let me three. It says 11B3. Factual contentions have evidentiary support.
No, these aren't factual contentions. This is lack of diversity. The idiot didn't do his research to find out what diversity was and what defeats diversity. 11B2, research, basic research.
Oh.
2, who is responsible for paying the fees assessed in the court by the court? The Walkers, Massey's clients, or Massey himself?
Massey. Massey?
Yeah, do you know why?
It's his mistake.
11C5A.
That's not encryption.
11C5A.
Against the represented party for violating.
The court must not impose a monetary sanction against a represented party for violating Rule 11B2.
That's why he hires an attorney.
That's why he's an attorney. That's right.
That's right.
That's right. So you can't pass this off to your client. You screw up, you pay. 3, did the defendants comply with the steps set forth in Rule 11C2?
Yes.
Let's look at the next page. Daniel, why don't you read that?
11C2.
Yeah, 11. It's on 422, A, B, and C.
They sent the plaintiff's lawyer a letter with notice of the complaint's deficiencies, but the opinion does not say that they gave the plaintiffs an actual Rule 11 motion, which they then filed with the court after waiting the requisite 21 days. B, if the defendants did not comply with this requirement, did the district court err by imposing sanctions? See Rule 11C3. Do you want to read 11C3?
Yeah.
11C3, on the court's initiative, on its own, the court may order an attorney, law firm, or party to show cause why conduct specifically described in the order has not violated Rule 11B. And back on page 422, C says, suppose the defendants had not raised the issue in any way, but the judge had directed his law clerk to scan all complaints for apparent failure or subject matter jurisdiction, as many federal judges do, so he could dismiss them on his own initiative as Rule 12H3 directs. Read carefully Rule 11C3, 4, 5, and explain whether the judge under such circumstances could have required that Massey pay the defendant's attorney's fees.
You don't have to read it out loud, just look at it.
Well, it was Massey's mistake, so he should have to pay the other side's attorney's fees.
Well, but an order must be preceded with an order to show cause. Okay? If the court's gonna do it on its own, there's no motion, right, coming from the other side. So if the court catches it on its own and wants to sanction them, then before it sanctions him, they issue an order to show cause why they should not be sanctioned. That's a notice provision, okay?
If the court does it on its own.
Yeah.
Okay.
If it does it on its own, then in order for a court to sanction somebody on its own, it first has to file a notice of order to show cause. I'm sorry, a notice of order to show cause, okay? You'll see this on multiple choice questions too, where, you know, the court catches it on its, catches the error or whatever it is, and is going to sanction the offending lawyer and issues an order sanctioning them. And then it'll say, is it valid? Most people will say, well, sure. It says right there that they can do it on their own, but the question will not include in the facts that they issued an order to show cause. So the answer is no, they can't.
Because they haven't issued.
They didn't issue an order to show cause. Okay, that's another trick question. You gotta remember that one. You guys should read, note 4 to yourselves, not now, later, on your own. Let's move forward. The takeaway that you should take on sanctions before we go to safe harbor is that sanctions are discretionary. Okay, Rule 11 sanctions are discretionary. They're limited to what is necessary to deter repetition of the conduct. Okay, you get it? These are sanctions because lawyers didn't do something they were supposed to do, not because they lost a motion. If you lose a motion, that's a fee shifting provision. But Rule 11 sanctions are different. They're basically punitive, okay? But they're limited to what is necessary to deter repetition of the conduct. All right? Both monetary and non-monetary sanctions may be imposed. So having said that, let's move on to Christian versus Mattel. And the model attorney, Mr. Hicks from Los Angeles. Wasn't he from Latham Watkins? I believe so.
Confirmed.
Yes, at any rate, I believe it was Latham. So go ahead, tell us all about Mr. Hicks.
Yes, okay. So the facts of the case, okay, so in 1990, plaintiff, Claudine Christian, she was an undergraduate at USC at the time and decided to create a marketed collegiate cheerleader doll called the Claudine. Had blonde hair, blue eyes, and was outfitted to resemble a USC cheerleader. Then she filed a complaint against Mattel, alleging that they obtained a copy of the copyrighted Claudine doll in 1996, the year she created the doll, and infringes overall appearance by developing a new Barbie line called Cool Blue. She said it was substantially similar to the Claudine, and she sought damages for.
Slow down. Slow way down. Okay.
Okay.
Now, one of them is the SC doll.
The what?
The first. The SC cheerleader, Claudine.
Right.
She was
USC.
an SC, that means USC
Right.
cheerleader doll, because the lady that created it was an SC cheerleader
Yes.
herself. And she's complaining about Mattel's Cool Blue Barbie doll, which, by the way, was baby blue. Who's baby blue?
I'm not.
Baby blue and gold.
Is it? UCLA.
Yeah.
I was like, what?
So she's complaining about the UCLA Barbie doll.
Oh, jeez.
Okay.
Well,
Keep going.
she sought damages for $2.4 billion. So in response, Mattel moved for summary judgment, which covered evidence that Cool Blue Barbie doll contained a 1991 copyright notice on the back of its head, saying that it predated the creation of Claudine by 6 years. And so Mattel argued that Cool Blue could not have infringed Claudine's head sculpture. There was a follow-up council meeting. Mattel tried to convince Christian's counsel Hicks that the complaint was frivolous, and deposition video showed that Hicks declined to inspect the dolls and even hurled Barbie dolls across the table.
Slow down.
Mattel, huh?
What happened at this deposition?
Well, he's
It's on videotape.
running video, yeah. He was shown to be very
What did Mattel's attorney do?
they told him to look at the doll and inspect it, and then Hicks said Hicks declined.
The Mattel doll.
Right.
And what would it show?
That on the back said the copyright of 1991.
Which preceded the SC doll.
Let's see by 6 years.
So theoretically, they could be suing her,
yeah. I wonder what she saw.
right? So what did he do? What did this brilliant lawyer Hicks do?
He said, no, I'm not gonna inspect it, and just threw him across the table or something.
He threw the doll
To the dolls at them, I guess.
and stomped out. Okay, so
And
what did Mattel do?
we served him with a motion for Rule 11 sanctions, and forced Hicks declined to withdraw the complaint during the 21-day safe harbor period. And of course, after that, the district court granted Mattel's motion for summary judgment and Rule 11 sanctions. Since something of the sort, if Hicks had done a more thorough investigation, he would have discovered that the Cool Blue and Virginia Tech Barbie doll has revealed that their copyright predated that of the Claudine. And then there's various other factors stated in 425, so 4 points. And then the Mattel's lawyer presented them with itemized a description of the work performed, and they ordered Mattel $501,565 in attorney's fees.
Who was ordered to pay $500,000?
Hicks was ordered to.
Yeah. Hicks law firm.
Okay. Okay, so the issue here, which Hicks appealed that decision, and so the issue is
Well, what were the basis for the sanction? What did the court say?
I think the court stated that they didn't really specify what the sanctions were for.
Well, they gave the trial court gave two reasons. Filing a meritless complaint and professional behavior, unprofessional behavior during discovery in that hearing. So apparently he misbehaved in court as well.
Okay. So then,
So what's the issue?
Does Rule 11 authorize sanctions for, among other things, discovery abuses or misstatements made to the court during an oral presentation? The rule that I found was on page 425. While Rule 11 permits the court to sanction an attorney for conduct regarding pleadings, written motions, and other papers that have been signed and filed in a given case, it does not authorize sanctions for, among other things, discovery abuses or misstatements made to the court during an oral presentation.
Right. So that if the sanctions were imposed for that, then it's improper.
Right.
So then what did the court do?
They conclude that the judgment needs to be vacated and remanded for district court to determine the actual factual and legal basis for its sanctions. So they need to determine what they really sanctioned it for. And I guess
You know what the court did after that? What happened after that when it got sent back?
I don't know.
How about looking at note 1A and B on 427? Want to read 1A and B out loud?
All right, so 1A says not only does he have to deal with whatever district court does on remand, but California, like a number of states, requires that lawyers against whom Rule 11 or similar litigation sanctions are levied report that fact to the state bar, which could institute the disciplinary proceedings. And B, and using the findings affirmed in the Rule 11 segment of the case, Mattel sued Hicks and his firm for malicious prosecution, toward which punitive damages are available. The California Appellate Court found that the malicious prosecution action could proceed, citing the Ninth Circuit opinion in support of its conclusion.
So not only did they get, not only, what happened was those 501,000 are gonna stick. The court just will go back and say, okay, it's 501,000 for violating Rule 11. Okay, not for the discovery and hearing stuff. And by the way, separately, the Ninth Circuit says, and you guys can get sued for malicious prosecution because you filed a meritless lawsuit. Okay? Where you think that Hicks is still practicing with Latham and Watkins? I looked him up. He's a solo. How'd you like to wind up as the subject of this kind of being in a case book? Okay, so the takeaway is Rule 11 sanctions are serious. Okay. Now we're going to go to we now filed our complaint, and we're going to respond to the complaint if you're a defense attorney. First of all, there's a chapter in the book, Chapter 8. Let's see, what's the title of Chapter 8? That's resolution without trial. Okay, we haven't gotten there yet, but there's a whole section there on default. Okay, we'll study that later. But what happens if you don't, if you're the defense and you don't respond to the complaint?
I'm guessing they default.
You can be found in default. The plaintiff files a motion with the court, and the defendant in default. And if the court finds that the defendant is in default, then they enter judgment against the defendant. And the only thing left is what's called a prove-up. Okay, which is the plaintiff will notice the deposition of the defendant if the defendant shows up, and they may request documents and other things, and then they're going to prove up their damages. Okay, and all the plaintiff has to do is the plaintiff testifies, these are my medical records, and I've had, and if they, if they've seen a psychiatrist, here are my psychiatric records, or a therapist or whatever. And if they haven't seen a psychiatrist, they can say, well, I've had extreme emotional distress, and that's worth $10 million for me. And the plaintiff's attorney can put that in, but the court won't give them $10 million. They're proving up their damages. Okay. And then they submit it to the court, and they ask the court to enter judgment against this guy. And if he doesn't show up, it's done. He's got a judgment against him. That's a default. We'll get into it in more detail later. Now let's get to defenses. And objections. First of all, Rule 11 sanctions apply to answers and pre-answer motions. Okay? I'm sorry. It applies to answers, not motions. Okay? And a motion does not require a party to set forth its version of the facts. It's a request for the court to take action. So Rule 11 applies to answers. Not a pre-answer motion. In terms of, I'm sorry, take it back. In terms of facts, if the law is misstated in a pre-answer motion, a motion to dismiss, you can get sanctioned if you misstate the law. Okay? In case I was not clear, Rule 11 applies to answers and pre-answer motions, except pre-answer motions, which are based on, that would be a 12b6. Failure to state a claim if the basis of the motion is failure to state facts which constitute a claim.
What time is it?
All right, we got time for this. Isabel, let's look at Rule 12B on page 299 of the supplement. You read us just 12B, how to present defenses.
Okay. Every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required. But a party may assert the following defenses by motion: lack of subject matter jurisdiction, lack of personal jurisdiction, improper venue, insufficient process, insufficient service of process, failure to state a claim upon relief can be granted, and failure to join a party under Rule 19. A motion asserting any of these defenses must be made before pleading if a responsive pleading is allowed. If a pleading sets out a claim for relief that does not require a responsive pleading, an opposing party may assert in a trial any defense to that claim. No defense or objection may be waived by joining it with one or more other defenses or objections in a responsive pleading or in motion.
Okay, so let's go back for a second. Okay. Notice there are 7 grounds for a motion to dismiss. 12B motion. That's it. So if you're gonna make a motion to dismiss, it's got to be one of these 7 grounds in federal court. There's no other basis. All right. You notice it, a motion asserting any of these defenses must be made before pleading if a responsive pleading is allowed. Okay, so if you're going to file a responsive pleading, you have to wait until you first filed your motion to dismiss. Got it? So say you want to assert self-defense, laches, whatever. You gotta wait. Can't do it till you've done this. Why? Because maybe the court's gonna grant the motion and it'll get dismissed and there'll be no more filings and the court doesn't have to deal with it. Okay? Now, take a look at 12G and 8. You read that?
Join motions. Right to join. A motion under this rule may be joined with any other motion allowed by this rule. Limitation on further motions. Except as provided in Rule 12H2 or 3, party that makes a motion under this rule must not make another motion under this rule, raising a defense or objection that was available to the party but omitted from its earlier motion. H, waiving and preserving certain defenses. When some are waived, a party waives any defense listed in Rule 12B 2 through 5 by A, omitting it from a motion in the circumstances described in Rule 12G 2, or failing to either make it by motion under this rule, or include it in a responsive pleading or in an amendment allowed by Rule 15A1 as a matter of course. When to raise others.
When to raise other defenses, okay?
Failure to state a claim upon which relief can be granted, to join a person required by Rule 19B, or to state a legal defense to a claim may be raised in a pleading, in any pleading allowed.
Any pleading,
In any pleading allowed or ordered under Rule 7A by a motion under 12C or at trial. 3, lack of subject matter jurisdiction.
so let's go back for a minute, what does that mean? Failure to state a claim upon which relief can be granted. Say you don't make a 12B motion. Then you raise it at trial. That's what it just says. What? C, at trial,
Oh, I got
okay?
it. Just didn't read
Get it?
that. Yeah.
Got it? So basically what this is saying is, you can raise it, you can raise that defense anytime. Okay?
Okay.
Isn't that basically a summary judgment motion?
No, this could be, you're the defendant. For some reason, you don't put in your answer or responsive pleading. I'm sorry, first you don't file a 12B6 motion. And when you file your responsive pleading, you don't say anything about failure to state a claim, which is hard to believe because everybody's got that on their word processor. Okay? All defendants have that one on their word processor, but for some reason, let's assume that they don't have a word processor and they screw up, okay? Or they screwed up on their program. So they don't put it in their responsive pleading, okay? And it goes to trial and the plaintiff puts on their case, and at the end of their case, the defense attorney stands up and he says, motion to dismiss. Failure to state a claim. Failure, they failed to state a claim upon which relief can be granted and there's no evidence. You can do it. Or they can do it at the beginning of the trial. Okay? You can do it orally. It doesn't say here that you, let's see. You don't have to do it. It doesn't say here that you, does it say here that it has to be in writing? I don't know. It just says at trial. That means you can do it orally. Okay? So, why don't we take a break? And we will come back to all of this stuff. And, which of you two want to do Zelensky?
I'll do it.
Okay. So you're gonna do Zelensky. That leaves Trish. You're
Yeah.
gonna- You're gonna do,
Aqua slide?
you wanna do Aqua Slide?
Sure.
Okay, then you're gonna do more,
Okay.
okay? What, I gave you Zelensky? Yeah. Or you gave yourself Zelensky?
That's right.
Okay, lucky you.
Yeah. I'll make it resident.
That's fine. We'll probably ask us. Would you like coffee? Is there some?
He might even do it.
We'll,
He might do the rest.
I can do it, but it's not a case. More is. I didn't read it. What? Because I didn't write that. Oh my God, I walked in. I just, my energy walked. Wow, I didn't do anything. I didn't get anything.
I kind of like, Michigan now too.
what?
Yeah. I'll try and catch up with them. Maybe he'll do it, since I'm writing notes over there.
I think all the good food spots around here close by the time we get out here. What? Well, we start class about like 6, so not really wait for dinner till then. And then when you get out, it's like it's past late dinner time.
Oh, I didn't even know this. I don't know her, but, he's the wife or the mother of his kids. She died.
No, it's that sucks.
I wonder why.
Shoot. Disease. Some disease. I think he's young, that's for sure.
They say cardiac arrest, she's pretty sad.
Oh, she had a heart attack? Jeez, yeah, that's, she had a
But she was only 47.
She had a heart condition.
Oh, she did? Oh, I didn't know that.
It's on the internet. That's my thing. She was no, I'm saying she wasn't right.
No.
Okay, so we just dealt with, failure to state a cause of action, and there's lack of subject matter jurisdiction. And remember, subject matter jurisdiction keeps coming up. If the court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action. Let's go to page 431. Daniel, why don't you read this?
431.
Yeah.
Number 1?
Yeah.
Arthur sues Beatrice in federal court for negligently inflicted injuries. Beatrice's lawyer believes that Arthur's suit suffers from several flaws. A. Arthur's complaint fails to allege that Beatrice's negligence caused his injuries. What motion should Beatrice make to raise this issue?
What? Looking at 12B. Look at 12B. There's only 7 motions.
So it'd be 12B6, failure to state a claim upon which relief can be granted.
Remember what I said, there was one motion that there's one rule number that I remembered when after 15 years of criminal practice, 12B6. By the way, when you bring your motion to dismiss, and it's based on more than just one ground, you think you bring separate motions? What do you think? Or is it one motion to dismiss based on, and then you state the different rule numbers. Look at that.
One motion to dismiss.
Yeah, one motion to dismiss. And you just list all the, 12, B, say 1, 3, 4, 6, 7, whatever. Then you just go into each round. Okay, let's do, keep going.
Arthur has brought suit in federal district court in Illinois. Beatrice's lawyer believes that Beatrice's contacts with the state are so meager as not to support personal jurisdiction. What motion should Beatrice make to raise this issue? 12B2, lack of personal jurisdiction.
Yep.
Okay. C, can Beatrice combine the two motions, failure to state a claim and lack of personal jurisdiction in the same motion, which we just discussed? Yes, she can.
Look at 12G1, guys.
Yeah, a motion under this rule may be joined with any other motion allowed by this rule.
Okay. Turn to the page. D.
Now move on to consider traps for the unwary. What if Beatrice first moves to dismiss for failure to state a claim and the court denies the motion? Can Beatrice now move to dismiss for lack of personal jurisdiction? Can she include the lack of personal jurisdiction as a defense in her answer?
12H1A.
A party waives any defense listed in Rule 12B 2 through 5 by omitting it from a motion in the circumstance described in Rule 12G2, or failing to either make it by motion under this rule or include it in a responsive pleading or in an amendment allowed by Rule 15A1 as a matter of course.
So what's the answer? No.
No, yeah, she can't move for lack of personal
No, it's
jurisdiction.
waived. Okay. E.
Reverse the timing. Suppose that Beatrice first moves to dismiss for lack of personal jurisdiction. She now wants to argue that the complaint fails to state a claim. Can she raise this argument? How? When? Not if she didn't include it in her motion to dismiss for lack of
Well,
personal.
look at 12H2 and 12. Well, look at 12H2 first.
Failure to state a claim upon which relief can be granted to join a person required by Rule 19B, or to state a legal defense to a claim may be raised, A, in any pleading allowed or ordered under Rule 7A, B, by a motion under Rule 12C, or at trial.
We just did that. So she can still raise it. What about 12I?
Hearing before trial. If a party so moves, any defense listed in Rule 12B 1 through 7, whether made in a pleading or by motion, and a motion under Rule 12C must be heard and decided before trial unless the court orders a deferral until trial.
Okay. And so it can be included in her answer, right?
Yes.
Number 2. Brian.
Andreas sues Bob in federal court for negligently inflicted injuries. Bob moves under Rule 12B to dismiss for lack of personal jurisdiction, improper venue, and insufficient service of process. The court denies the motion on all 3 grounds. Can Bob include in his answer defense that Andreas' complaint fails to state a claim?
Um, 12H2A.
It can be asserted during trial, yes. 12B, 12
H2A,
H2, and
big A.
yeah,
What
so,
does that say?
and in any pleading allowed or ordered under Rule 7A.
Okay,
And then it's answered yes.
so they can, yes,
Okay.
right?
Yes, it can.
B,
Can Bob include in his answer the defense that the court lacks subject matter jurisdiction?
well, H3.
H3. If the court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action. So, yes,
Yes.
it can. And then C, suppose Bob does not raise the lack of subject matter jurisdiction either in a pre-answer motion or in his answer, but the judge hearing the case notices in reading case documents that there appears to be no basis for federal subject matter jurisdiction. Is this defense waived? What should the judge do?
Is the defense waived?
The lack of subject, no, it's not.
It's never waived.
You can do until appeal.
And didn't I just explain what the judge could do?
It's just.
What?
Issue notice to
Show cause.
show causes.
That's it. Okay. Basically, other than the 12B motion, there are three other motions, pre-answer motions that can be brought. A motion for a more definite statement, that's 12E, which is just I don't think that the complaint is definite enough, and I want a more definite statement in the complaint or answer. It's rare. Almost nobody brings it. Why? Because even if it were granted, what's the result? You just get a pleading with more words in it. Okay? So if you're a reasonably competent lawyer and you can tell what it is that the claim is or the defense is, you move on. You're not going to waste your client's money or the court's time making the other side provide more words. Okay? And even if that weren't the case, it's almost never granted. So it's a complete waste of time. So therefore, it's very rare, okay? But it's available. There's also a motion to strike, Rule 12F. Read for yourself on 12F, pages 432 and 433. And then there's motion for judgment on the pleading. Read to yourselves pages 433 and 434 on that, wherein the court, go back. The motion to strike is not a motion to dismiss. It's a motion to strike certain aspects of the pleading from the pleading. So usually we'll bring that motion in combination with a 12B motion. Okay? Say there's multiple causes, multiple claims. Say there's like 6 or 7 different claims, and you got a 12B6 motion to dismiss counts 2, 3, and 5 for failure to state a claim. Okay, and then there's some other claims that will remain if that's granted, and you make a motion to strike certain portions of some or all of those claims as being surplusage or for some reason, you don't want them in the complaint because it looks bad. For example, it says, it's a lawsuit against Daniel. And it says that, in addition to Daniel doing all these terrible things, Daniel is a no good son of a bitch. Well, I mean, it might be true, but but Daniel doesn't like seeing that in the complaint, so he asks his lawyer to make a motion to strike that, which the court will do because it has no
Pertinence.
it's just surplusage. And beyond that, it's really not nice. So you get rid of it, okay? Get it? Okay. So read all this stuff on the motion to strike and a motion for judgment on the pleadings. Motion for judgment on the pleadings is something that you would file based upon, let's say that it's a complaint for civil rights violation. Make it easier. Make it a lawsuit involving property, claim for property, and the plaintiff is suing for breach of contract on a sale agreement, and the defendant files. Go back. Plaintiff files a copy of the contract. Okay. Defendant files an answer that includes an affidavit or declaration by the defendant attaching a couple of letters. And the letters disclose that the contract was not breached. Okay, just as an example. Okay, so based on the pleadings, the defendant can file a motion for judgment on the pleadings. It's not a summary judgment. It's just a motion based upon what's in the pleadings. Okay? You understand?
A motion for what based on the pleadings?
It's to dismiss. It's for judgment. It's for judgment on the pleadings. Plaintiff could file based on the pleadings. Let's say that there's no letters. Okay? And based on the contract, and what's in the pleadings, in the complaint, it says this is the contract and defendant failed to live up to their end of the deal in the contract, and the answer to the complaint doesn't say anything about that. I can file a motion for judgment on the pleadings. Okay? They didn't deny it. Therefore, we're entitled to judgment on the pleading. Okay? That's different than a motion for summary judgment. Motion for summary judgment is usually filed after discovery, and you include in it answers to interrogatories, responses to requests to produce, documents to produce, in response to a request to produce documents, and deposition testimony, and maybe some declarations. Okay, so that's a whole evidentiary thing. A motion for judgment on the pleading is based just on the pleading. Everybody understand that? Okay, so let's look at page 434. Isabel.
George, a student at a private law school, files a complaint alleging that the school's code of student conduct has violated his First Amendment right. The school's lawyers intended to argue that the amendment applies only to state action and thus does not apply to a private institution. What motion should the school file to raise this argument at the earliest possible time? Well, if it's the school, it would,
They're saying it doesn't apply to them.
so
12B6, right? That's 12B6. Failure to state a claim. Okay, go ahead. 2.
same facts as in note 1, except that the school has already filed an answer denying a violation of Georgia's constitutional rights. What motion should the school file to raise its state action defense?
Based on what I just previously said, before you started reading.
So 12B6?
No, before you started reading these notes and problems, what was I talking about?
Oh, to dismiss,
Huh?
the motions to dismiss.
It's not called a motion to dismiss. Judgment on the pleadings or a motion for summary judgment.
So I thought a motion, I thought a motion for judgment on the pleadings was if they don't deny.
No. Motion for the pleadings is just what's on the pleadings, okay? So let's say that and that's a matter of law, okay? On this example, it's a matter of law, okay? So they file an answer, and in the answer it says, school has already filed an answer denying a violation of constitutional rights, okay? So they can file a motion on the pleadings, okay, for judgment on the pleadings. Court may deny it and say there's enough in the pleadings to go forward. Then they take a little discovery, maybe attach a declaration if they don't want to go through depositions and stuff, and they file a motion for summary judgment.
Okay, so the difference with those two is one is before trial, one is during trial.
They're both before trial. Assume the motion for summary judgment is like a mini trial based on documents. Okay? But a motion for summary judgment has to be filed and heard at least 30 days before trial. Okay? And it's usually it has to be filed like within, it has to be filed no later than 90 days before trial and heard at least 30 days before trial. Okay? You don't have to remember that now. We'll get to it. There's a whole chapter on motions for summary judgment. All right, keep going.
George, having transferred to a public law school, files a similar claim against it, except that one paragraph of the complaint also states that the dean is a cretinous old fool. Cretinous old fool. Explain why you would not recommend a 12B6 motion as an expeditious way of dealing with this complaint. Well, a 12B6 motion is to failure to state a claim upon which relief can be granted, and it's not here. It's just saying that he claims that he's a cretinous old fool. It doesn't say that he's failing to.
So what would you recommend?
Motion to strike.
Yeah, exactly right. Okay, B.
Suppose the defendant's answers denying that it has violated Georgia's constitutional rights. Why will a motion for judgment on the pleadings not dispose of the case?
It just says it denies it. We deny violating his rights. So the complaint says they violated his rights, and the complaint says we deny it.
So everybody would do that, so that's why,
Yeah, there's not enough facts.
yeah.
You can't how can you file a judgment for judgment on the pleadings to work?
If you're just,
It would be like judgment for a motion for judgment on the pleadings would work on the case that we previously read where the guy on the face of the complaint included in his complaint that a number of the defendants live in South Dakota and that the plaintiffs live in South Dakota. Motion for judgment on the pleadings, right? No diversity. That's just an example.
okay, let's see, with what motion might the defendant have success given the allegations in the complaint? Would be motions for judgment on pleadings.
You already did it. Motion to strike. And a motion for summary judgment. But that you gotta, we're not gonna get into motions for summary judgment right now, okay? All right. So that's the answer and motions. I'm sorry, that's motions. Now we go to responsive pleadings. That's an answer. Now, first of all, this is Rule 12, which is on page 298. This is where you got to get into some memorization about time to file something, okay? So they're within 12A1A little one, you know, I, and little two I's, big B and C. You have to file within 21 days of being served an answer or other response of pleading with a summons and complaint. Or if service is timely waived, within 60 days after request was sent, or 90 days if outside the US. Remember that? So you got to file your answer or other response of pleading within 21 days or 60 if you waive service. Within 21 days of being served a counterclaim or cross-claim. Within 21 days of being served with an order to reply, unless otherwise ordered. What that means is the court can say you have more time than 21 days. It will usually not be less than 21 days. Okay. So we're still with Isabel. We're going to go to the answer, Rule 8B. Can you read Rule 8B3? These are denials. What would be in your answer?
general and specific denials. A party that intends in good faith to deny all the allegations of a pleading, including the jurisdictional grounds, may do so by a general denial. A party that does not intend to deny all the allegations must either specifically deny designated allegations or generally deny all except those specifically admitted.
Okay, this is the most common response. Okay? The requirement is defendant may deny only those allegations it actually disputes. The failure to deny any allegation any allegation that's not denied is deemed admitted. So any allegation that you want to deny, you better deny. Otherwise, it'll be deemed admitted. And you're not going to have a happy client. Let's look at the difference between general and specific denials. First of all, a general denial is basically on your word processor, you have a general denial that defendant denies each and every claim and all claims herein stated and yada, 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 okay? It's just a general denial. It's not a specific set of denials. And you can file a general denial. There are issues with it, but let's talk about Zielinski.
All right, so
Right now, we're doing general denials. Okay?
So Zielinski was operating a forklift for J.A. McCarthy Inc. when he was injured by Sandy Johnson, who was driving another forklift. Zielinski sued Philadelphia Piers Inc. and alleged that his injuries were caused by Sandy Johnson's negligent operation of a forklift, and the forklift was owned by Philadelphia Piers. Zielinski alleged that Johnson was an employee and agent of Philadelphia Piers at the time of the accident. Sandy Johnson had worked for Philadelphia Piers for 15 years and was not aware that the company had transferred ownership of the operation and that Sandy Johnson had been in fact working for Carload Contractors Inc. Johnson mistakenly testified that he had worked for Philadelphia Piers at pretrial depositions attended by reps of Philadelphia Piers who had made a general denial of the allegations in the complaint, but did not clarify that it had transferred the operation to Carload Contractors. So Carload Contractors, Philadelphia Piers, and the insurance company that provided insurance to both companies were aware that Zielinski had filed a suit against the wrong company. Zielinski didn't discover that he sued the wrong company until the pretrial conference. So Zielinski moved to stop Philadelphia Piers from denying the facts alleged in the complaint because the company had allowed him to believe that they were true. In effect, anticipating dismissal of the complaint based on false statements of the parties and suing the wrong parties. So for the issue, I have
Did they share something, Philadelphia Piers and Carload Contractors?
they share. Do they share insurance companies?
Yeah, they have the same insurance company.
Yeah.
That's an important fact.
All right, so for the issue I had, whether a defendant should be stopped from denying alleged facts in a complaint if he has made an ineffective denial of those facts and knowingly allows a plaintiff to continue to rely on them.
Okay, what was the Pennsylvania rule?
Pennsylvania rule.
This is an ineffective answer. This is the category of case or issue here is an ineffective answer. And it's in the case there, it talks about there was no federal case on point, but there's a Pennsylvania rule. I'll do it. Where an ineffective answer has been filed, an allegation of agency in the complaint requires a statement to the jury that agency is admitted if the time allowed to amend an answer has passed. And had that happen?
Yeah, the time had passed.
Right. So Zelensky was asking for a ruling and jury instruction that the forklift was owned by Piers and that Johnson was its agent. Because the general denial, that's the problem with a general denial where you just say, we deny each and every allegation and every fact contained therein or something like that, okay? Which is basically a CYA denial. That's what a general denial is. It's a CYA denial. Everybody know what CYA means? Okay. So it didn't say it denied agency, that Johnson was its agent. Okay. That would be a specific denial, that Piers denies that Johnson was its agent. That's a separate denial. Didn't do that. Just we deny each and every allegation and every fact contained therein or something like that.
It makes sense because they knew why, right? You know, that he had sued the wrong company, so it should have been a specific denial.
Well, if they knew that, yeah. At the time, they didn't really know that, but it's wise lawyering to any important legal theory that may provide a defense, even though you think that Johnson was your agent. Maybe there's some factual issues that you don't know about that would establish that he wasn't your agent. You just don't know what they are. So a good lawyer would just say, would include, Piers denies that Johnson was its agent. Okay, it doesn't have to be true. That's something that can be fleshed out during the course of discovery. Remember, you can have inconsistent pleadings. You can have inconsistent defenses. Okay?
As long as it's certified, not verified, right?
Yeah, you're certifying.
So you're certifying.
You've done your initial investigation. You found out that this guy worked for Piers for 15 years. As far as you know, he worked for Piers, but maybe something happened and you don't know about it. So, okay, or maybe it turns out that this guy has some kind of a contract that you don't know about that says he's an independent contractor. Okay, and he has nothing to do with Piers. It's just a machine that belongs to Piers. You don't know that. So you throw it in. But they didn't do that. It's a general denial. That's a danger of a general denial. So let's keep going. So what happens?
Okay, so for my rule, I have a general denial is ineffective if some of the claims denied are true and not at issue. So a defendant who knowingly makes inaccurate statements may be stopped from denying those statements at trial. So Philadelphia Piers should have made specific denials we talked about of the parts of the complaint it knew to be false, and should have admitted the parts that were true. The specific denial would have warned Zelinski of his mistake. Under Pennsylvania law, when an improper and ineffective answer had been filed in time allowed to amend the answer and pass, the party will be stopped from denying the allegation, and any improper allegations will be deemed as true. So Philadelphia Piers doesn't have a right to knowingly, continue on with a mistake by its acts of omission. So the court rules that they're stopped from denying the agency of Sandy Johnson and the company's ownership of the forklift.
That's it.
They pretty much say that if Zelinski's complaint were dismissed, he'd be deprived of his day in court, and they want to give the plaintiff his day in court.
Yeah, but they applied the Pennsylvania rule and stopped Piers from claiming that Johnson was not its agent, and granted a jury instruction that instructs the jury that Johnson is Piers' agent, even though that wasn't the truth. Right?
Right.
That's an equitable rule. That's good. You did it. Does everybody understand that and what happened? All right. They weren't going to let Piers get away with escaping liability when it knew or should have known that Johnson wasn't its employee and it never advised Zelinski of that fact. So Zelinski goes along happily litigating this case until the statute of limitations is run against Carlo. Okay? Note 5. What's note? Where's note 5? What page is that?
439.
Okay, so I'm going to read you just 1C. At some point before trial, the confusion about who was responsible for the forklift became obvious to both parties. Why didn't plaintiff at that point simply voluntarily dismiss the suit against Philadelphia Piers, which permits voluntary dismissals, and file a new complaint naming the correct defendant, Carlo? What prevented that? Statute of limitations. Okay? Read 5 to yourselves. That's a big long one. So that's general denial. Now let's go to Rule 8C and affirmative defenses. What are affirmative defenses? Did we look at that before? Some of them? Didn't we just read that?
Yeah, well, the 12B or the 12C.
12B, those are all affirmative defenses.
Eight C.
Wait a minute. Yeah, 8C. So go back to 8C. Look at all those things. And they're all affirmative defense. That is a non-exclusive listing. Okay. There are more. I'll see if I can find my template that I used that listed, I think we had 30. I mean, some of these defenses were ridiculous. I mean, it was like defenses that we found, you know, in the Magna Carta. But at any rate, you know, rather you should plead more defenses than apply than not have enough. That's the example of that previous case. Zelensky, plead as many defenses as you can possibly plead and make them specific. Okay, Jones versus Bach on page 410. We did that last week. That was the case involving the prisoners in state prison. Okay. And let's look at notes 3 and 4 on page 441.
Note 3. Now suppose that on remand after the decision in Jones v. Bach, the warden defendant is offered a chance to amend the answer, figuring that everyone understands that he will change Jones's exhaustion remedies.
He will challenge.
Oh, John. Sorry.
You got to slow down.
Figuring that everyone understands that he will challenge Jones's exhaustion remedies, warden does not amend. The case comes on for a hearing at which the defendant wants to offer evidence tending to show that Jones did not exhaust his administrative remedies. Jones could object to the evidence, arguing that the pleadings failed to raise the issue of exhaustion. By admitting the defense of failure to exhaust administrative remedies in the answer, the defendant had waived the defense, and evidence concerning a waived defense is inadmissible.
And there's the citation. You don't have to read the citation. But read the facts of that case. In trespass case?
In trespass case, easement was an affirmative defense, and court should have barred the defendant who failed to plead an easement from introducing it into evidence.
Okay, do 4 too.
Take another variation on Jones. This time the defendant warden does amend the answer on remand, alleging failure to exhaust as an affirmative defense. Read Rule 7A and explain why Jones cannot file a pleading denying the warden's allegations of failure to exhaust.
Unless ordered by the court. That's the only one you got to read. So go to 7A.
7A. So Rule 7A pleadings. Only these pleadings are allowed. A complaint, an answer to complaint, an answer to a counterclaim designated as a counterclaim, an answer to a cross-claim, a third-party complaint, an answer to a third-party complaint, and if the court orders one, a reply to an answer.
What would that be? Why can't Jones file a pleading denying the warden's allegations of failure to exhaust? Failure to exhaust is a denial. That's something he puts in his answer. What would, if the plaintiff were to file something saying that's not true? I did exhaust my remedies. What would that be?
An answer to an answer.
What?
Is that an answer to an
An answer to an answer? That will be a reply. That's a reply.
I see.
Can you file a reply? What?
I thought you can't.
What does it say? What does 7A say about replies?
If the court orders one, a reply to an answer.
Yeah, so the only thing he can do is file a motion
Motions.
seeking to file a reply, which are usually denied. It's unnecessary. Okay? But he could file a motion seeking leave to file a reply. In most cases, pleadings stop with the answer. There is no reply. Okay? It is possible you can file a motion seeking leave to file a reply, but it's unusual. So what are the proper challenges to an answer? A challenge is not a reply. It's a motion. You can file a motion to strike. You can file a motion to strike an answer. You can file a motion for judgment on the pleadings. And you can file a motion for summary judgment. That's how you challenge it. Or you go to trial. Okay? Go to 444 and 445. Clara, what do you?
Okay,
You don't have to read the intro, just go to 1.
just one, number one.
No. You're gonna read all of these.
Oh, I'm gonna read all of them, okay. So,
Well, you guys want to just go through them one at a time? You can do that. You still get to do number 1.
I know.
Go ahead.
So plaintiff files a complaint against an automobile dealer and automobile manufacturer. The complaint, which is properly before the court under diversity jurisdiction, alleges that plaintiff was injured in an accident caused by a defect in the vehicle's steering mechanism. Manufacturer believes that the vehicle was not defective when delivered to dealer, and that any defect must have been introduced by dealer when the vehicle was being prepared for delivery to customer. What pleading, if any, should manufacturer file?
We gotta file something.
Well, let's see here, because,
How about an answer
an answer to a counter,
with a denial? What would they deny? They didn't effectively manufacture.
oh, okay.
Answer with a denial that it was defectively manufactured. Okay? That's pretty simple, isn't it? 2, Trish,
Okay, plaintiff files a complaint against landlord alleging that the plaintiff was injured when a water heater on landlord's premises exploded and injured the plaintiff. The complaint invokes diversity jurisdiction, alleging that the water heater was defective and asserts that the landlord is liable for having a defective water heater. The landlord files an answer asserting that the complaint fails to state a claim upon which relief can be granted because the doctrine of strict liability for defective products only applies to manufacturers and sellers of products, not to a landlord. At trial, plaintiff proves that the heater was defective, but the landlord continues to assert that it is not liable because strict liability does not apply to landlords. Plaintiff moves the court to strike this defense on the ground that it should have been made in Rule 12b6 motion prior to answering and was therefore waived. What results? I think the landlord wins.
is
Um,
not waived?
what's that?
Yeah, it's not waived. That's what you said.
Right.
Okay, you know why?
It's one of the 12 rules. 12H something.
Well, what?
12H, as I recall, 12H something. H.
12H2.
12H2, okay. Which
It
states,
can be raised in pleadings or a trial.
right.
Thank you.
Okay.
Daniel. 3.
Same facts as problem 2, except that landlord's answer denies liability but fails to assert that the complaint fails to state a claim upon which relief is granted. Is the defense waived? Um,
12H2. Hint, hint, hint. H2.
yeah, I know. So they can raise it at trial by a motion under 12C or in any pleading allowed under Rule 7A.
Yeah, it's never waived. Okay? So it's not waived. Got it? Everybody get that? All right. Isabel, 4.
Plaintiff files a complaint for breach of contract. Defendant files an answer but the complaint is barred by a 1-year statute of limitations. Upon receiving the answer, plaintiff's attorney concludes that the affirmative defense is totally without merit. The statute of limitations applicable to a breach of contract claim is 4 years. The 1-year statute cited in the answer's affirmative defense applies only to negligence claims. Should plaintiff file a 12B motion to dismiss the affirmative defense? Well, they should because they didn't state a proper defense, which failure to state a claim upon which relief could be granted. Would it be that they should file it because the other party failed to state a claim upon relief could be granted?
Well, is this part of 12B? You can only file a 12B motion to dismiss. Is that list, is this listed?
Well, wouldn't that be under, wouldn't that be a 12B6 motion?
Huh?
Wouldn't a 12B6 motion?
Wouldn't that be a reply?
Oh, shit.
Can't do it. It's not 12B. Okay,
Okay.
got it?
Okay, so if
No
not,
reply. Basically, forget replies. Okay, if it's a reply to to an affirmative defense or a general denial, if it's a reply to whatever the defendant files, you can't do it unless it's a motion to strike or a motion on the pleadings. Okay? Get it? Okay. How about B?
If not, what 12 rule motion could plaintiff file to assert the affirmative defense is without merit? No, that's the-
Motion to strike. Okay? 12F. You're gonna read all this stuff, right? You guys? You read all this stuff in the textbook. 12F, which describes in more detail a motion to strike. Do 5A.
Okay. Plaintiff alleges negligently inflicted injuries in an auto accident. Defendant denies negligence and counterclaims for his own injuries. Plaintiff believes he was not negligent. What should response to the counterclaim be?
Counterclaim.
Is a counterclaim.
Well, you file counterclaims like a claim.
So you
Look at 12B.
told me. Failure to state a claim.
Look at 12B. It's right there.
Yeah. So
Yep. Failure to state a claim upon which relief can be granted.
that's what it says. What should plaintiff do if?
Hold up, but also in Rule 7A3, it says that you can file an answer to a counterclaim, remember? What should the plaintiff do if the counterclaim alleges negligence but fails to allege causation?
Failure to.
12B6, failure to state a claim
Yeah.
or motion to strike, 12F. Motion to strike a counterclaim. Remember, go back to 7A3. You can file an answer where it lists all the different pleadings that can be filed. One of them is an answer to a counterclaim or a cross complaint. Okay? Okay. Now we go to Rule 15A, amendments before trial. This is on page 304 of the supplement, is the rule. Okay? There are two goals. You know what an amendment to a complaint or a pleading would look like? It's usually amendment to a complaint, okay? Is you got something wrong. Maybe it's the name of the defendant. It's a corporation and you get the name of the corporation wrong. You know, it can be anywhere from it's an LLC and you've got an Inc. to the name of the corporation is just wrong. You got the wrong name for the corporation. It's the right entity, but the name that you got for it is wrong. Okay? You sue Mobile Oil and it's really excellent. Okay? So what do? You dismiss your complaint? No, you file leave to amend. File a motion asking the court to allow you to amend the complaint to state the right name. You know, you fall on your sword, you say, I got the wrong name. We need to amend. Okay? The goals of this statute are twofold. For easy amendment, they want it to be easy, and to avoid prejudice to the other side. The time to amend and respond is in 15A1 and 3. A1 provides for amending as a matter of course. It reads, a party may amend its pleading once as a matter of course. You can just file an amendment. You don't have to ask the court to allow you to do it. You can just file the amendment, okay? But you have to do that within 21 days after serving it. Serving the complaint, or if the pleading is one to which responsive pleading is required, 21 days after service of a responsive pleading, or 21 days after service of a motion under Rule 12B, E or F, whichever is earlier. A3 sets forth the time to respond unless the court orders otherwise. Any required response to an amended pleading must be made within the time remaining to respond to the original pleading or within 14 days after service of the amended pleading, whichever is later. Let's go to Beek versus Aquaslide. The problem here is prejudice. Remember I said there's two goals? One is easy amendment, the other is prejudice.
Who's doing Aquaslide?
I am, Trish. So this case takes place in 1972 in Illinois. Jerry Beek was severely injured in July of 72 while using a water slide. He and his wife, Julie, sued Aquaslide and Dive Corporation, alleging that it manufactured the slide involved in the accident, and they sued for more than $2 million in damages on theories of negligence, strict liability, and breach of implied warranty. So Aquaslide does the opposite of what these past two cases do. They don't deny that they made the slide. They actually admit that they made the slide, but they later moved because they had insurance companies look at the slide, and the insurance companies deemed it that it was Aquaslide slide. So the company just took their word for it, I guess.
Well, what was the answer?
Yes.
What was the answer that they filed? The insurance company tells that this is your slide. So what's their answer to the complaint?
Well, they eventually amend the complaint.
I didn't ask that.
Okay.
They admitted that they had manufactured it.
Right.
Right.
That's what I said.
Okay. So
I said, unlike the other two cases, they actually admitted that they made the slide.
yeah, that was their answer. They admitted it.
Right.
So then what happened?
So then, the president of the corporation comes out to look at the slide, And he finds that the slide actually has no markings that indicate that it was made by Aquaslide. So then they request to leave to amend the complaint, the answer, saying that no, they are not the manufacturers.
Okay, well, what had happened between the
The
time
statute of limitations had run out.
on filing it against somebody else?
Yeah.
Okay, so what happened?
So the district court actually granted the leave to amend. And there was a separate trial on whether the defendant, there was a separate trial on the,
Liability.
on the liability. But of course, the defendant, the plaintiffs were upset, and the issue of the case was that did the trial court abuse discretion by permitting the defendant to amend the complaint?
Wait a minute.
I mean,
So
the answer.
there was a separate trial. And
Right.
what happened in the trial?
Trial. Hold on.
Why were the plaintiffs upset?
Well, because
The court
because they
granted
were
to amend this. There was a statute of limitations that prevented them from being anybody else, and then they had a trial. What was the result of the trial?
the trial ruled that the court did not abuse its discretion in granting the leave to amend.
No, that's not a trial. That's a motion. Then there was a trial, and they lost.
Right, on the issue of the manufacturing, right. The plaintiff lost. They sued for $2 million, but they lost.
And that's why they're appealing. So what's
Right.
the
The issue is, should the court have been allowed to, did the trial court, and the district court also affirmed the trial court's ruling, did they abuse discretion in granting leave to amend Aquaslide? Answer.
Yeah. What's the rule?
The rule is, in the absence of any apparent or declared reason, such as undue delay, bad faith, undue prejudice to the opposing party by virtue of allowance of the amendment, the leave sought as the rules require be freely given as at the discretion of the district court. So they ruled in favor of Aquaslide.
Okay. That was it?
That's all I have.
Okay. The rule in this case is that prejudice must be shown. Okay, remember I said that the issue is prejudice?
Yeah.
And so the court holds the prejudice must be shown. The burden is on the party opposing the amendment to show prejudice. The trial court must inquire into the issue of prejudice to the opposing party. In this case, the plaintiff alleged he was prejudiced because his action was foreclosed by the running of the statute of limitations, and granting the motion would sound the death knell to the litigation. Plaintiff's argument requires the trial court to assume that the defendant would prevail at trial, and that plaintiff would not be able to proceed against other parties. The trial court was unwilling to make that assumption. On the record, the trial court did not abuse its discretion. I still don't understand this. I can't understand why that isn't prejudice. But that, that the statute of limitations run and they can't bring in anybody else, I think that does sound a death knell. But at any rate, this demonstrates that if a trial court makes a finding that they didn't show prejudice, a court of appeal will be reluctant to reverse. That's not the point of the case. For us, the point of the case is that the party opposing a motion to amend has the burden of showing prejudice. And obviously, that's a heavy burden. How is that? Okay. Look at page 451. To be, I'll just read it. Later phase of this lawsuit reveals something not discussed in this opinion. Aquaslide and its president were aware that others had been copying their slides. There had been several other lawsuits in which it had turned out that the slides were made by competitors. And they've got Beak versus Aquaslide and Dive Corp. Suppose that information had been presented to the court in this lawsuit. Under those circumstances, would it have been an abuse of discretion had the trial court denied permission to amend? And there could be a showing that Aquaslide knew that there were other people out there basically ripping off, competitors making slides that look like their slides. Okay, and so now they're making a motion to amend, and they knew about that back when they admitted it.
Mm-hmm.
You add that fact, would it be an abuse of discretion for the trial court to deny permission to amend? Yes. Okay. You guys got?
Okay.
Okay.
Can I ask you something?
Yeah.
Real quick?
Yeah.
You know how why didn't they raise the affirmative? Why didn't they deny right off the bat? Because I thought you're supposed to raise every defense in an answer.
Their insurance company told them there was their slide. Okay?
Yeah.
We don't know any more than that. We only know what the facts state. There's a thing here about implications on page 452. If you haven't read it, read it. It's all about this case. Oh, the hell with it. Read it. Trish? I'll read it. Forget it.
Oh.
The Beak opinion above did not end this litigation. The Beaks filed a second suit in state court, still against Aquaslide. This time, however, they did not claim a defective product, but reckless misrepresentation made in the pleadings in the federal litigation. Plaintiff's theory was that misrepresentations in the answer had caused the Beaks to lose their chance to sue the real manufacturer within the statute of limitations. The Beaks presented evidence summarized in Note 2B, showing that Aquaslide should have been on notice that there were counterfeit slides on the market. The case came before the Iowa Supreme Court twice, once in 1981 and once again in 84. In 84, the court upheld a recovery of over $3 million based on the misrepresentation theory. But analogizing the Beaks' claim to a legal malpractice action, the court also said that in order to prevail, the plaintiffs would have to show not only that they would have recovered a judgment against the actual manufacturer, but also that the judgment would have been collectible. The court remanded the case for yet another trial on the issue of collectibility of the award. Would you expect the Beeks to be able to make this showing? What do you think? They got to show that they could have collected against a bootlegger.
Yeah, but if bootlegger has insurance, they probably could have collected it.
I don't know. That's the point. Depends. Except how many insurance companies do you think insure bootleggers?
Mm.
No. Or I doubt that there are any. Anyway, they had a tough row to hoe. Let's go to statute of limitations and relation back. This is the most important part of this chapter. Okay. Rule 15C. Federal Rules of Civil Procedure, Rule 15C. Page 452 of the textbook. Rule 15C is on relation back is on the bottom of page 304. This rule provides that an amended complaint filed after the statute of limitations has run will relate back to the date of the filing of the original complaint if three elements are satisfied. One, the claim must arise out of the same transaction or occurrence as the original complaint. We've seen this one before, right?
Yeah.
Two, the new party received notice of the action so that it would not be prejudiced, due process, right? And three, the new party knew or should have known that it should have been named as the original party, but for the mistake about the proper party's identity. If the amended complaint is found to relate back, the statute of limitations is not deemed to have run. Does everybody understand that? So you got to meet all three of those elements of 15C. Okay? For the relation back doctrine to apply. So what is the same transaction or occurrence? Moore versus Baker.
Okay, so the facts of this case are the plaintiff Judith Moore consulted defendant Dr. Baker about a blockage of her carotid artery. The doctor recommended surgery and warned her about its risks. Mrs. Moore signed a consent form, and the operation went badly and left the plaintiff severely and permanently disabled. So the plaintiff sued the defendant, and in her initial complaint, she alleged that the doctor had violated Georgia's informed consent law by failing to advise her on an alternative theory. So this was on August 6, 1991, which was the last day before the statute of limitations ran. And then her complaint asserted allegations of of informed consent. And then 20 days later, on August 26th, she moved to amend her complaint to assert allegations of negligence by the defendant. And the district court refused to allow the plaintiff to amend her complaint on the grounds that the statute of limitations bars the claim. Asserted the plaintiff's proposed amended complaint unless the amended complaint relates back to the date of the original complaint. So Mrs. Moore appealed. So I have as the issue whether Mrs. Moore can amend her complaint to allege negligence on her surgery from its original complaint alleging failure of informed consent. So as a rule I have, a plaintiff cannot amend their complaint when the new claim does not arise out of the same conduct, transaction, or occurrence as the claims in the original complaint.
So since the original complaint focused on the doctor's actions before the surgery and then the amended complaint focused on them afterwards, the court said that it would not have given notice to Mr. Baker of the claim put forth in the amendment, and the original claim asserts that Baker did not adequately inform Mrs. Moore, while the other ones was after his conduct afterwards, which involved actions that occurred at different times and involved distinct conduct from the acts alleged in the original complaint.
Right.
So they said that the amendment does not relate back to the original complaint, and so it was affirmed that she couldn't use the same.
Statute of limitations applies. You can't amend.
Mhm.
Okay. Now we've got Bonerb
I'll do that.
versus Richard J. Karen Foundation, 1994. You want to do that?
Yeah.
Okay.
So this is a diversity action and claim of sought damages for personal injuries allegedly sustained when slipped and fell while playing basketball on defendant's basketball court in November 1991. So in his original complaint he filed in October 1993, the plaintiff was injured while he was a rehab patient at defendant's Westfield facility and was participating in a mandatory exercise program. He alleged that the basketball court was negligently maintained by defendant. On July 5th, 1994, the court granted plaintiff's motion for substitution of new counsel, and on September 1st, 1994, he moved to amend his complaint to add a new cause of action for counseling malpractice. The defendant objected to the amendment on the grounds that the counseling malpractice claim does not relate back to the original pleading and is barred by Pennsylvania's 2-year statute of limitations.
What was the proposed amendment? What did it want to add?
He wanted to add counseling malpractice.
Well,
Which is,
let's go back. The complaint alleged, the original complaint alleged several instances of defendant's conduct, such as failure to maintain the premises safely, failure to warn, failure to inspect, and failure to properly supervise and or instruct plaintiff. Right? The amendment sought to add that, quote, the rehabilitation and counseling care rendered was negligently, carelessly, and unskillfully performed. Okay? So, what's the issue?
let's see. So can an amendment that changes the legal theory of the case be appropriate if the factual situation upon which the action depends remains the same and has been brought to the defendant's attention by the original plea?
And is it the same, the issue is it the same conduct, transaction, or occurrence?
No, it's not.
What?
Oh, let me go.
What's the rule?
Sorry. So let me set the rule first. So an amendment that changes the legal theory of the case is appropriate if the factual situation upon which action depends remains the same and has been brought to defendant's attention by the original pleading. So I just reversed the issue. The court said that the allegations of original and amended complaints derive from the same nucleus of operative facts involving injury suffered by the plaintiff on November 1st, 1991. So the original complaint alleged that the participation in the exercise program was mandatory and that the injury was caused by the defendant's failure to properly supervise and or instruct the plaintiff. So they said that these allegations not only provided defendant sufficient notice of general facts surrounding the occurrence, but also alerted defendant to the possibility of a claim based on negligent performance of professional duties.
So that means that it's the same transaction or occurrence. Okay, very good. But let's get this straight. I'm not going to do this on the whiteboard because it's almost 9:30. Okay, this case gives you a test for same transaction or occurrence, which you need to know. and that is for it to be the same transaction or occurrence. The factual situation remains the same, that's one. Okay, they're not changing the factual situation. And two, the defendant is was put on notice by the original complaint of the possibility of a claim. Okay? Get it? It's pretty common sense. We're not going to find that it's the same transaction or occurrence if you try to change the transaction or occurrence, okay? It's got to be the same. The facts got to stay the same. And if you're bringing and if you're going to change the plaintiff, I'm sorry, if you're going to change the defendant has, or it's the same defendant, but it's a new legal theory, they have to be on notice from the facts that that claim was possible. Okay? I mean, and as a defense attorney on this one, you'd be sitting there going, well, he only alleged that they negligently maintained the basketball court and that they didn't properly supervise. And boy, are we lucky they didn't say anything about, malpractice. Well, that's because obviously it's in the facts and you can deduce that from the facts. And now they just want to add a few allegations here so that you've got malpractice as well as negligent supervision. Okay? Also, note, because this is important, and these things, when you're on an essay question, in this case, discovery wasn't cut off, and there was an adequate opportunity to file pretrial motions. Okay? So those are equitable issues that if it's in the facts of an essay, you would throw in. If you're arguing relation back and it should relate back, you say, well, he's not prejudiced because there's plenty of time. The discovery hasn't been cut off. They got plenty of time to do more discovery and to file any pretrial motions. Okay, that's a no prejudice thing. Just a minute. All right, forget this. So remember, do the self multiple choice testing at the end of this chapter, and have a good Thanksgiving.
Me too. Me too.
And we're done with pleading.
You better not.
I'll take you another brand.
I can't believe.
No, for real, you can use it to your work. It's really, you're not. I'll think about it. I'll talk about it.
Isabel left, I'll tell her later. So I'll send you guys a summary for the chapter, unless you don't want me to.
Yeah, no, please do. That was a long chapter.
Bet you didn't think we'd finish it, huh?
No, I didn't. It's filled with the sign. Yeah. Sure, I'll make sure she signs it, I'll give it to Veronica.
Yeah. Okay. And tell Isabel I'm sitting at someone.
Have a good Thanksgiving.
Okay, you too.
Thanks.